as rich because it's the president and his lawyers who are actually using a kind of magic words theory to explain why what they're doing isn't attack. If we don't call it attack, just call it a regulatory tariff, it's not actually attack. What were the taxes that the revolutionary pamphleteers were opposed to? They were opposed to import taxes. The ones that led to the Boston Tea Party, they thought import taxes were legitimate only if they were authorized by their legislature, which is exactly what the president is now trying to take the power away from Congress to do.
On November 5th, 2025, the Supreme Court held oral arguments in the case scrutinizing President Trump's sweeping worldwide tariffs imposed under the International Emergency Economics Power Act, IEEPA. The outcome of this case will determine the immediate future of Trump's tariffs, but more fundamentally, it presents an opportunity for the Supreme Court to take specific, expansive action regarding the foundational principle of American constitutional law, the separation of powers, and set a precedent for or against Congress's handing over its constitutional powers to the executive branch. The result can either severely hinder the move towards authoritarianism in the United States or destructively fuel it. Today at the Ayn Rand Institute podcast, we're talking about how the Supreme Court should act to make the law of the land more objective and preserve the liberty of Americans. I'm Robertas Bakula, and with me is senior fellow Ben Bayer. Hey, Ben.
Hi, Robertas.
Ben, I will be mostly asking you questions because you've written and researched this and followed the cases extensively from April and before. But I want to set some context for the audience before we dive in some questions. So the context and what happened this year, how we come to where we are today, is that President Trump imposed sweeping tariffs, including those that are just blanket 10% baseline on all imported goods, including from the allies of the United States, by executive fiat, beginning of what now is known as the Liberation Day on April 2nd. And he justified this move, these tariffs, under the International Emergency Economic Powers Act, I will refer to it as IEEPA from now, justified it on the grounds of alleged emergencies like trade deficit. In May, the U.S. Court of International Trade ruled those tariffs illegitimate after some suits were filed by private businesses like VOS Selections, a wine importer, and some states. The ruling was halted pending appeal to the U.S. Court of Appeals for the Federal Circuit. It held arguments on July 31st, and all of that led to the consolidated case, now Learning Resources v. Trump, to reach the Supreme Court for the oral arguments that just happened. Who were the plaintiffs in that case?
And the two major plaintiffs are small businesses that rely heavily on the ability to import either their products or components of their products in order to make a living. Learning Resources is a company that makes educational games. And VOS Selections, as you mentioned, is a wine importer. They kind of pick the best foreign wines that their customers might be interested in. And so we're talking here about companies that are paradigm cases of depending heavily on foreign trade for their very existence. And so at the very least, what this is obviously an example of is these tariffs are severely restricting their economic liberty, their ability to make the choices they need, voluntary choices, with regard to foreign exporters, in order to pursue profit, in order to pursue happiness. These are Central American rights. And it's not just limited to them, because while these small businesses basically stand or fall according to their ability to profitably import goods from abroad, there are bigger companies that can get away without having to worry so much about the tariffs because perhaps they have enough of a lobbying effort in Washington and enough they're big enough that they can afford to lobby for exemptions to these tariffs. And so the big manufacturers, the big tech companies, all have a presence in Washington. They're able to lobby for these exemptions. and sometimes escape the worst consequences of these tariffs. But one further consequence of that is that they become increasingly dependent on the favor of the administration in Washington, on the Trump administration. And that means that the Trump administration can basically pressure these companies to comply with its will in order to get these kinds of exemptions. And that can apply to anything from their manufacturing policy, where they choose to manufacture, to the kind of positions that they take on public policy issues. So this is a major power grab from the administration that is a threat to not just economic, but I would argue intellectual freedom in America as well. And so the outcome of this case is, I think, really crucial to the future of America.
So let's dive in. A lot happened in courts now, but now that we're in the Supreme Court, we'll focus primarily on the oral arguments that happened on November 5th. And of course, here at the Ayn Rand Institute, we're not only concerned with the legal issues, but with a little more deeper fundamental philosophical issues at hand. So what are those questions at issue in the case, Ben?
Right. So the petitioners, as I understand it, having read a lot of the briefs and then, of course, watched these oral arguments, have a kind of two-pronged strategy. Their first strategy, and it's the one that I think they are putting the most effort into because it's the one that's the most realistic that they can expect to actually win in court, is to argue that IEPA, the 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 law that the president is citing, is the basis for the authority for these tariffs. They simply argue that this law does not actually grant him the power to impose these tariffs. And so they're not dominantly challenging the law itself. They're saying it simply doesn't imply the power that the administration says that it does. But they do have an interesting, I think, fallback option. They argue that if for whatever reason this law is interpreted to give the president the power to impose these tariffs, then that would be an unconstitutional delegation of powers from Congress to the president. And this, I think, does get to the broader and deeper legal philosophical question that I think is clearly at stake in this debate, whether it's their frontline argument or not. And that is, as you referenced earlier, Roberta, the separation of powers. Because if Congress were able to delegate this kind of sweeping authority to the president to basically impose unlimited tariffs for as long as he thinks there's an emergency, that is undermining separation of powers. Separation of powers is, of course, one of the key achievements of the American founders. The idea that there's a division between executive, judicial, and legislative branches, and that it's the power of Congress, the representatives of the people, to pass laws, including the specific powers that are enumerated in the Constitution, to tax and to tariff, and that Congress can't just say, well, we're giving up this power to the president. And as long as we decided to do it, he can now be the one to legislate. He can be the one to declare war. He can be the one to impose taxes and tariffs at his will, as though he were a king. And it's the fact that too much power was concentrated in the executive in the form of the English monarchy that, of course, we had a revolution against Great Britain. It's ironic or sad. It's just sad that this is the thing we have to debate in the year 2025, 26, which is the 250th anniversary of the Declaration of Independence. So the fact that this key achievement of the founders is now suddenly, or at least very dramatically, being threatened is tragic, and the court has a chance to step back from this brink. And so we have to look at these oral arguments and see, what are the prospects that they're going to.
What is the main argument, or how do the plaintiffs make their main argument? What are they building the case around? And what do you think about it?
Yeah, so that main frontline argument, the one that they're, I think, investing most in, that this law, IEPA, simply doesn't grant the power to impose tariffs, is, well, for one thing, the law doesn't mention the word tariffs. But also they are arguing, I think, very persuasively, that a tariff is a tax. And Article 1, Section 8 of the U.S. Constitution gives Congress the exclusive power to levy taxes. And so if a tariff is a tax and Congress doesn't have the power to delegate its taxing authority, then IEPA shouldn't at least be read to delegate that authority, especially since it doesn't actually mention the word tax. It doesn't even mention the word tariff, for that matter. So their major argument is the power that the president claims is just not in the plain language of the law that he's asserting. Um, and I think it's a very persuasive argument.
Okay, well, the president's team seemed to not agree with that, and so I will play a clip. We'll start playing clips from the oral arguments to show how both sides present some of the things we say in their own words. And the first clip is the president's team making an argument that tariffs are not taxes. So let's see.
So I want to make a very important distinction here. We don't contend that what's being exercised here is the power to tax. It's the power to regulate foreign commerce. These are regulatory tariffs. They are not revenue-raising tariffs. The fact that they raise revenue is only incidental. The tariffs would be most effective, so to speak, if no person ever paid them. If they did achieve their goals, if they...
Counsel,
Okay, so tariffs are not taxes, they would be most effective if nobody actually paid them and no revenue would have been collected. What do you think about that?
That is quite an argument. One thing to note, so yeah, they're trying to argue that there's a taxation function of tariffs, but there can also be a regulation function of tariffs. I should mention the power to regulate foreign commerce is also an enumerated power of Congress in a different part of Article 1. Now, later we're going to talk about their argument for why it's allegedly less problematic for Congress to delegate that to the president than it is to delegate the taxation power because of the president's foreign policy authority. That's itself problematic. But yeah, keep in mind, even the power to regulate foreign commerce is a congressional power. But there seems to be broad agreement that if anything's an exclusively congressional power, it's taxation. So yeah, they need to make an argument that it's not really a tax, that it's just a regulation. And the argument that they give it in their briefs is that whether it's a tax or simply a regulation, in effect, has to do with intent. If the intent is to raise revenue, then it's a tax. If it's not, then it's not. And that's what makes this particular argument so galling and really absurd on its face. Because if it wasn't the President Trump's intent to use these tariffs to raise revenue, it's impossible to make sense of what he's been telling the American people and what he was telling voters for over a year, because he regularly boasts about how many billions of dollars these tariffs raise, how they're helping us allegedly balance the budget deficit, how he's going to be able to give rebates now to American citizens using that money. It seems quite clear that the president's intent has been to raise revenue with these tariffs. And there are some people who argue that you can't use statements of the president to judge his intent and to assess the law, that all that matters is the argument that the government's making in its briefs. I find that kind of dubious, especially if the whole idea of what makes it a tax is the intent. How else are you going to assess his intent aside from looking at his statements? But then the sort of very surprising fumble is that the president's major brief, written by the the Solicitor General, who we just heard from, D. John Sauer, actually quotes the president's statements in the brief. So his statement of intent is practically right there in the brief, making it very difficult for the government to dispute that these are taxes simply on the ground that they're there for some other regulatory purpose. And as Justice Sotomayor raised in another part of the oral argument that we're not going to look at, if it really were just an intent to regulate trade, say to reduce the importation of fentanyl or punish countries who are exporting it to us, or to solve the trade deficit problem, well, then there would be a very easy solution to that that didn't involve tariffs, a solution that involved actual enumerated powers from IEPA. You could just impose embargoes. You could just impose quotas. Those are powers that the law specifically allows for, but they're not doing that. And so that raises the question in my mind, is it really their intent just to regulate, or do they actually want to impose revenue? I think they want to impose revenue. I think it's obviously a tax. And, whatever you think of the power of Congress to tax, it's far better, I think, that you have 435 representatives who get to decide whether it's going to be imposed, than for just one man to decide it. That's why the founders put it as a core Article 1 power. And the fact that the president is now trying to usurp that core power is a real threat to the rule of law.
So let's turn to the claim that the president and the president's team is making, that the power, he's not taking the power, he's been delegated. He's been given that power by the Congress through the IEPA to impose tariffs. So are they wrong? Why do you think they're wrong, and are they wrong to think that it's a power that's been legitimately delegated and given to them by the law?
Right. And so like the best argument they could make, I think, is it's not really a tax. It's a regulatory tariff. Congress conceivably has more power to regulate tariffing regulatory power than they do have the power to delegate tax power. And so then it comes to a question of, well, okay, does IEPA actually even delegate tariffing? And the president's main argument is they get it from the fact that there's a part of the text of the IEPA code that says Congress, that once it's been passed, Congress is saying the president has the power to decide on ways to regulate imports and exports. So they're trying to get it in through this regulate clause. And the question, of course, is that actually doing it? And one thing that I think Justice Sotomayor points out is there are 16 different laws that Congress has passed which do, in fact, give the president the power to impose tariffs in certain very delimited circumstances. While the Congress retains the power to impose tariffs, they say, well, when the trade deficit rises above a certain amount under certain circumstances, president can engage in an investigation and after a certain number of months report to Congress and say that he is declaring this tariff of no more than a certain amount for a certain amount of time, after which it expires and then can be renewed. So there's a very definite process by which the president can actually impose tariffs. There are a lot of laws that actually give him this power to do it. And when Congress wanted to give the president this power, it said so explicitly, using the word tariffs in those laws. But this law simply does not do that. And as has been argued all over the place, no previous president since IEPA was passed in the early 1970s has ever used it to try to impose tariffs. And so the question is, why shouldn't we expect Congress to have used the word tariff in this legislation if it had actually meant to delegate tariffing power? And they have an argument for it that we should actually look at.
There was some discussion about that. Let's see.
Oh, I should mention one more thing about this clip, which is that it presupposes discussion of a precedent, a Supreme Court precedent, Federal Energy Administration versus Algonquin, where there was an argument about whether or not the word tariff needed to be in the law. So let's hear what Sauer says.
And the conclusion it came to, it directly addressed and rejected the argument that the D.C. Circuit had accepted in that case, which is that when Congress wants to delegate the authority to tariff, it uses a consistently explicit and well-defined approach, which is to use these magic words, tariff, tax, impost, and so forth. No, the Congress is not bound to use that particular formulation when it wants to confer this power.
Can you explain this, Ben? I'm a little lost in what he's trying to say.
Sure. So he is saying that in the Supreme Court precedent, this Algonquin precedent, that Congress decided that Congress doesn't need to use the magic word tariff to actually confer tariffing power. Now, let's leave aside for the moment what is in fact, I think, the major legal fallacy here, which is that this is not about IEPA. This precedent was not about IEPA. It was about Section 232 tariffs, one of those previously mentioned cases where Congress does give the president power to impose tariffs. Now, it doesn't use the word tariff in the particular clause that was at issue in this court case. It does, however, talk about duties and similar concepts to tariffs earlier in the context of the same law. And so the fact that it doesn't mention it in this one clause, all that the Supreme Court's deciding here is, yeah, you can look at context and see, well, we know from context they're actually talking about tariffs, whereas the context of IEPA is totally different. The context of IEPA is, in effect, foreign policy emergencies. And so we'll come back to what that, I think, actually means. But the kind of philosophical point that I wanted to make about what Sauer is saying here is I think it's rather rich. And he is here complaining about a requirement that there be magic words used, that there's something magic about having to have the word tariff in a law that gives the power to tariffs. Now, it's rich because it's the president and his lawyers who are actually using a kind of magic words theory to explain why what they're doing isn't attack. If we don't call it attack, just call it a regulatory tariff, it's not actually attack. Even though all of the facts about what the president is doing point to the fact that this is attack. It's being used to raise sensitive revenue that the president's boasting about. He probably wouldn't have done it otherwise. And so it's really the president that's trying to use words in a magic way. And it's not an expectation of magic. You think that if a legislature wants to give a president a certain kind of power, that it uses the clearest, most concrete, most determinate word to actually convey that it's their intent to delegate that power if they want to do it. Absence a lot of context, it's the more concrete word that's going to deliver the most objective meaning. And throughout the rest of IEPA, there are all kinds of other concrete words that are used, like nullify, block, prohibit, void, when we're talking about what Congress can do, what the president can do upon the passage of this law with regard to international trade when there's a designated emergency. So on the one hand, he's bemoaning the expectation that Congress should write objective laws by saying, oh, you're asking for magic. On the other hand, elsewhere, he's celebrating what he takes to be the absence of objectivity in this law, because throughout the brief, they talk about how, the words that the words that IEPA uses to grant powers to the president are quote unquote capacious. They assign such sweeping powers. There's so much room in there for anything. And in effect, they can mean anything the president wants them to mean. And I think to her credit, Justice Barrett called this out, saying, no, the words that IEPA uses to assign the president powers, they assign powerful powers, the power to nullify, block, prohibit, void. But that doesn't mean that their meanings are capacious. It doesn't mean they don't have definite meanings. They definitely do have definite meanings. And then Justice Kagan added the point that there's good reason to think here also that Congress was very deliberate about the words that it chose, because the IEPA law was actually the heir to previous law, the Trading with the Enemies Act, which gave even more extensive power. This was a World War I era law that we'll come back to talking about. I think it was significant that it was called the Trading with the Enemies Act, because that's really what the foreign policy's context is, and we'll come back to that. So the Trading with the Enemies Act, which they call TWIA, gave even more powers. Congress took some of them out, which means it was very deliberate about the words that it left in, leading us to think, well, shouldn't we think carefully about what these words definitely mean and not just think that they're capacious? Now, of course, what Sauer and what the president want to hang their argument on is that there is a word in IEPA that they want to make everything hang on. That's, of course, the word regulate. But if it was context that made the previously mentioned Algonquin decision tell us that it was okay to not use the word tariff if you were imposing the power to give, if you're giving the president power to impose tariffs, the problem is that that context just isn't here. That the context of the word regulate in IEPA has nothing else to do with revenue raising, it has nothing else to do with taxation, has nothing else to do with tariffs. It's all about, in effect, emergency powers during wartime. And that's just not the context of tariffs, something we'll come back to. The rest of everything else that we have about the context of this law that was passed in the 70s, including statements of intent by Congress, indicate that it's about things like freezing the assets. It's enemy regimes, as a member of enemy regimes. It was used, for example, in the late 1970s when during the Iranian Revolution, when the Shah was deposed and when the Ayatollahs took over, and their assets were frozen because there was an actual foreign policy threat emanating from Iran. So there are reasons to think Congress didn't intend it to be used for tariffs. There's no real reason to think otherwise. And in fact, the word regulate is it's the least well-defined term on the list of powers, and that's going to be something that'll raise questions about whether there's actually just something wrong with this law. I should also mention that going back to what is the frontline argument of the petitioners here, which is they are saying quite simply that the IEEPA doesn't give the power to impose tariffs, and that's even though it talks about regulating. One of the kind of clever linguistic arguments that the petitioners make here is if you look at the actual paragraph in which this word regulate appears, it says the president may prescribe by means of instructions, licenses, or otherwise investigate, block, etc., regulate importation. So it's not even saying it gives him a carte blanche power to regulate. He can only regulate by means of instructions, licenses, or otherwise. And their point is, well, what the president is doing is not regulating by means of an instruction or a license. A license would be like, are you allowed to trade or not? It's not, I'm going to put a tax on it. There's then an argument in oral arguments about whether tariffs are equivalent to licenses or license fees. I don't find the argument very persuasive. I won't go into the details. I don't think it's too important. There's then a question of, well, can you put the regulating through means other than licenses, that otherwise part, can you read it out? And this is like the details that they're getting into in this argument. And boy, it would be a lot to think just because they said through otherwise mechanisms regulate, and we'll assume that to mean tariffs. I mean, they could have said tariffs, but they didn't say it. This is going to transition us into the next issue, but Neil Gorsuch seems somewhat skeptical that this kind of frontline argument to say, well, a tariff is not a license, that it's not the proper mechanism of regulation. He seems skeptical that you can just assume it's not in the otherwise. And so he seems to think that the only way to actually show that the president does not have the power to tariff is to argue that there's actually something wrong with this law, that there's something wrong with the law insofar as it delegates powers to the president that Congress should not be able to delegate. Non-delegation is a major jurisprudential concern of Justice Gorsuch, I think for good reasons. The president has enumerated powers in the Constitution. First and foremost, he has the power to execute the laws. That's what the executive function is. He also has commander-in-chief authority over the military, which is not quite the same as the power to execute the laws. You can make an argument that it's sort of it's presupposed by the power to execute the laws, because if you can't defend the country from an external invasion, then you're not going to be able to execute any laws. And so he has definite enumerated powers, some of which are very, very powerful. And the question is, what does that imply? The president's lawyers are arguing basically that there's no problem with separation of powers for delegating him the power to tariff, as long as you think of those as the Congress's power to regulate foreign commerce. They think it's less problematic for the president to be delegated the power to regulate foreign commerce because it's not the taxation power. And when it's the power to regulate foreign commerce, it has more affinity to one of the arguably core powers of the president, which is discretion over foreign policy. And we need to get into why they think that.
Yeah, so the opponents of tariffs can concede seemingly that, yes, the president should be able and can do something like impose quotas, shut down trade, put fees on licenses, and that's all under IEEPA as well. So what do you think of that concession? And more generally, if you look at the IEEPA, is there anything legitimate about the powers that it grants to the president that he should have in the capacity as the head of foreign policy? Or put it in other ways, is there anything worth saving in IEEPA if on a condition that, or if the tariffs are being struck down?
Yeah, I think this is what gives the president's argument its plausibility. There's a real kernel of truth here, and it's a kernel that I think is captured and expressed by IEEPA, which is that, the president is the commander-in-chief of the military. And especially if you're in a war with a foreign aggressor, you need to have the authority to shut down trade with the aggressor for national security reasons. If someone's trading with the enemy, and that was the original name of the act from the early 20th century, they are in effect aiding and abetting an enemy of the nation, and they don't have the right to engage in that kind of trade. That would be siding with the enemy. And so, to the extent that the president has authority over foreign policy, which is extensive, he doesn't have the power to declare war. But even, I would argue, without a war declaration, he still has military authority. I mean, if we're attacked by someone and Congress hasn't yet had a chance to declare war, the president needs some kind of independent authority. And there's a long history of his having this kind of authority, which was eventually codified in the War Powers Act, to have discretion about how to use the military to repel attacks. And so when we're talking about an actual military conflict, yeah, that implies the ability to shut down trade or restrict trade in different forms. Or if we're talking about someone who's who's threatening force against us, the president needs to be able to threaten to shut down trade or take other punitive measures or sanctions against people who would engage in trade with the enemy. So, yeah, I think there's a lot that's in IEEPA that's necessary, and that's a corollary of the president's rightful foreign policy authority. The problem with the argument that the problem with the kernel of truth is that this kernel does not grow into the seed, into the plant or the tree that the president wants it to grow into, because we are not talking about a military conflict here. We are not at war with the entire world, even though these tariffs have now been imposed against the entire world, including against our closest military allies. I should mention, even the precedent, the judicial precedent that the president is citing for why it is that the president of the United States should have special discretion over foreign policy to shut down trade, is a case from the early 20th century where there was an actual war between Paraguay and Bolivia, and Curtis Wright, this arms manufacturer, was selling arms to someone in that conflict, and the president, as commander-in-chief, didn't want us to get involved in that war, and so decided to shut down sales of weapons to one of these countries. That's an actual war. It's not a case where there's a trade deficit and we think that there's a economic threat posed by even the trade of our longtime allies. And the closest that the president's lawyers can come to explaining why the president's foreign policy authority and ability to exercise control over trade in wartime, in virtue of being commander-in-chief, the closest they come to showing why that power gives him the power to impose tariffs, is based on a set of precedents, mostly from the 19th, early 20th century, where, in fact, the president did impose fees on a certain kind of trade in wartime. But these were still not tariffs. And just to bring this out, I think we should look at what one of the petitioner's lawyers, Petitioner Gutman, who is coming from one of the states, had to say to instruct us about the actual history here. I think this is really important history to know when thinking about those historical precedents.
The 19th century cases about the president's inherent Article II authority to with respect to in a wartime with respect to importation is not the power to impose tariffs on imports coming into the United States. That is not what any of those cases were about. They were about the president's power, in a wartime as an occupying military force to impose tariffs in occupied territory, that was in Mexico, in the Philippines, in California. The Civil War case might be the closest case, but even there, what we were talking about were essentially, there were licensing fees, but they were export fees. They were fees that were being imposed on the exportation of cotton from the occupied South into the North.
Yeah, so this is really important. It's part of the context for the legislative context for IEEPA. As I mentioned before, it was the heir to the Trading with the Enemies Act. The Trading with the Enemies Act was imposed in World War I, so that we could cut off trade with Germany, which was an actual military belligerent, and it was based on this history of non-judicial precedents of actual cases where the president did shut down trade in these kinds of military cases, and all of them, as Gutman mentions, are cases of actual military conquest. So he's talking about the Mexican-American War, he's talking about the Spanish-American War, he's talking about the Civil War, and it's all concerning occupied territory where we've gone to war with a nation, we've won some territory, and we're saying basically to the people living in that occupied territory, if you want to send your exports to our country, you have to pay a fee. That's not a tariff where American citizens are paying in peacetime for the privilege of trading with our allies. It's very, very different. And he mentions the Civil War case. That's where we occupy Tennessee at the very beginning of the Civil War. And so now Tennessee is basically occupied enemy territory. The reason that it sounds closest to what we're talking about with domestic peacetime tariffs is, well, you think, well, trade with Tennessee, those are American citizens. Well, of course, no, they weren't really, because they were members of the Confederacy who were now just being given the permission to trade because they had been aggressors against us. And so this is just very, very different from peacetime tariffs against allies, which are imposed indefinitely, as opposed to against specific belligerents and specific aggressor territory, and only to the extent that the conflict is ongoing. Of course, once those wars are over, there's no longer these export fees imposed against the foreign citizens. And that's the context that just keeps getting dropped in this argument, even by the justices who are more sympathetic to the president's argument. And here we should listen to what Brett Kavanaugh had to say on a similar point. This also, he's basically asking a version of a question you asked earlier, Robertas, which we didn't get a chance to tackle yet.
Your interpretation of the statute, as she pointed out, would allow the president to shut down all trade with every other country in the world, or to impose some significant quota on imports from every other country in the world, but would not allow a 1% tariff. And that leaves, in the government's words in its brief, an odd donut hole in the statute. Why would a rational Congress say, yeah, we're going to give the president the power to shut down trade? I mean, think about the effects, but you're admitting that power's in there.
Yeah.
But can't do a 1% tariff. That doesn't seem, but I want to get your answer, to have a lot of common sense behind it.
Yeah, it doesn't seem to have common sense if you drop the context of a wartime, right?
Right. So it's a clever sounding argument. I mean, he's basically saying, if you have the power to shut down trade with the whole world, why not just give you the power to have a 1% tariff? And what Gutman goes on to say is, it's not a whole, it's a whole different kind of pastry, which is a clever response. Though he doesn't really explain himself. He doesn't say why we're talking about something so fundamentally different. And I think the core fundamental difference he should have said something about is there's a basic difference between military and non-military contexts. So if you are in an actual wartime situation where you're dealing with specific aggressors who are threatening the integrity of your territory, it doesn't even make sense to charge a tax on trade with them. That implies you think it's fine for the tax to keep happening and you want to profit from it. Why would you want to profit from an activity that's aiding and abetting the aggressor? It doesn't make sense to have a tariff in a context like that. It makes sense to shut down trade. So there's a fundamental difference between shutting down trade for military reasons and taxing commerce, which is a peacetime activity. And yeah, the IEEPA would give you the power to shut down trade with the entire world if you were at war with the entire world. which has, of course, never happened and nobody would ever expect it to. The only reason we're talking about posing a tariff on the whole world is we're not at war with them. And of course, it's kind of ridiculous to pretend like we are at any kind of war with people who are actually our military allies. So like protecting us from foreign aggressors by means of military force and the shutting down of trade, that's a basic function of government. That's a basic, proper function of government. It makes sense that IEPA would grant that power to the president. Raising revenue is not a basic power. It's at most a means to the end of the other basic powers. And it's very important that it's a power of Congress.
So to put one more dot on an I of this issue of delegation of what can and cannot Congress or should be able or should not be able to delegate. So apart from the approval stamp by the Supreme Court or a denial of such stamp, by what means should the Congress, do you think, in either case, in this specific case or just in any case, determine whether they can legitimately delegate some function to the president?
Yeah, so there's a long doctrine in the United States, been around since the early 20th century, going back to a case called J.W. Hampton, that says if Congress is going to delegate a power that it is enumerated in the Constitution to the president at all, it can only do so to the extent that it does it basically in a delimited fashion. And the doctrine has come down, has been called the intelligible principle doctrine. The idea here is they define a very delimited way in which the president has discretion within a certain delimited sphere. We're not giving away the power to the president. We're just giving him permission to exercise it in a delimited way for a short period of time, kind of under our scrutiny, because we don't have time to cover all these things in the way that the president does. So that's the intelligible principle doctrine. I think it makes sense. As a non-lawyer, I think it makes sense if you're going to delegate something that is your power, just like if you're in a non-governmental context, if you're signing a contract with someone, if you're giving someone permission to do something with your property, you want to have a definite contract saying what exactly they're allowed to do with it and what they're not. And that's especially important if you're talking about a governmental context where powers that the government has have to be enumerated by the Constitution. And if you're going to do what looks like an exception to that, you've got to have enumerated guidelines for it. That's how you maintain rule of law, as opposed to, kind of autocratic authoritarianism where whatever anyone says goes. And so in the oral arguments, one of the things that's discussed is a very recent case, the consumer research case. It's just from just a few years ago, where basically the FCC was imposing a certain kind of tax on people who had phone lines. And the question was whether or not this violated non-delegation doctrine. And the argument that's made is, well, here, Congress didn't seem to have a problem with giving the president the power via the FCC to impose this tax. And that's true. But the argument from the petitioners is that in this case, it was okay because there was a very definite intelligible principle. The president wasn't able to raise a tax through the FCC above a certain level for more than a certain amount of time, et cetera. So there were all kinds of specific conditions that were attached in this case. And so the court in the consumer research case didn't have a problem with the idea that the Congress was giving away its power of taxation to the president. It was only within very limited bounds. And so the question is, do we have something like that here with IEPA? That is, if we did read this as giving him the power to tariff, which again I don't think we should, but if we did, would it be consistent with this intelligible principle test? And one of the points that Justice Kagan makes is that there are, in all the other 16 or so laws where the Congress does give the president power to impose limited tariffs, there are again very specific conditions attached to it. The question is, does IEPA impose those kinds of conditions? And we should listen to what the Solicitor General, D. John Sauer, had to say about why he thinks it does.
This statute has its own constraints. They are constraints that are appropriate for the context, which is internationally arising emergencies. They are carefully crafted by Congress to address that, and they are admittedly different. They're in Section 1701. The president has to make a formal declaration of a national emergency, which subjects him to particularly intensive oversight by Congress, natural lapsing, repeated review, reports, and so forth. It says you have to consult with Congress to the maximum.
I mean, you yourself.
My view is that it's basically a joke to regard what he's talking about here as any kind of intelligible principle style delimitation of powers. The only delimitation he's saying here is, well, it has to be if the president thinks there's an emergency and he tells us that. And that's it. That's the constraint. There's no constraint on the level of tariff that he can impose. No constraint for the amount of time it can be imposed. No constraint on who it can be imposed on. He's now imposing it on every country in the world. Like one of the justices points out later, President Trump decided to impose an extra tariff on Canada because he didn't like the ads they were running in Toronto about with Ronald Reagan saying something negative about tariffs. In another case, he imposed a new tariff on Brazil because he didn't approve of the way in which ex-President Bolsonaro had been charged with trying to overturn the election. Like he is using it for any old reason he likes. If that is because of a so-called emergency, that emergency constraint is no constraint at all. And it's made even worse by the fact that by the logic of IEPA, there's no way to subject whether or not there is an actual emergency to judicial review. And notably, this isn't something that comes up even in the present argument. Like they're not debating in the oral arguments about whether this really is an emergency. And that's because they don't think they can. They don't think they can if, in fact, we're talking about presidential discretion over foreign policy. It's not for the courts to decide whether emergency is actually happening. And so the question is, should the simple fact of an emergency, is that enough constraint so that this is not violating the non-delegation doctrine? To me, it doesn't seem like this is any kind of constraint. And
neither does it for Justice Gorsuch, right?
it doesn't seem
he thinks that by the same standard, Congress could basically delegate away almost anything. So let's listen what Gorsuch has to say.
I want to explain to me how you draw the line, because you say we shouldn't be concerned because this is foreign affairs and the president has inherent authority, and so delegation off the books, more or less. If that's true, what would prohibit Congress from just abdicating all responsibility to regulate foreign commerce, for that matter, declare war, to the president?
We don't contend that he could do that. If it did,
Why not?
Why not?
yeah, I mean, there's a back and forth at this point in which it's not really clear why not, by the logic of the argument that the respondents are making. Because their argument is you can delegate anything that has to do with foreign policy, and then the president has exclusive discretion. So we should look at the next clip where Sauer says, well, maybe it's not full delegation as long as there's just deference to the foreign policy power of the president.
Can you give me a reason to accept it, though? That's what I'm struggling and waiting for. What's the reason to accept the notion that Congress can hand off the power to declare war to the president?
well, we don't contend that. Again,
Well, you do. You say it's unreviewable. There's no manageable standard, nothing to be done. And now I think tell me if I'm wrong. You backed off that position.
maybe that's fair to say.
Okay, all right.
That would be, I think, an abdication. That would really be an abdication, not a delegation.
I'm delighted to hear that, Okay. All right.
That's quite a moment, Ben.
It's an emperor has no clothes kind of moment where he's exposed the logic of the argument, and Sauer is in effect embarrassed by the logical consequences of it. Because what Gorsuch has been searching for in this conversation is what exactly is the theory here about when you're allowed to delegate foreign policy powers, and to what extent. And because it seems by the logic of your argument, Congress could just decide to give the president the ability to declare war. That's one of its foreign policy powers. It's enumerated in the Constitution. But he has not explained why they can't delegate that. It seems like it would be absurd for them to be able to delegate that. because it would mean then the president is back to being a king. He doesn't want to confess that, but the logic of the argument dictates it. So he basically has no real theory of what can be delegated, which I think means he has no real theory of what constitutes proper separation of powers, which means there's really no theory here at all of what is the proper role of government. And I think this is a moment that shows that Sauer he's a legal court jester. He's basically there to do the president's bidding, to use to pull out every argument he can to try to rationalize what the president wants to do. It's obvious that these arguments don't stick together. It's obvious that they have ridiculous, absurd consequences. We saw a moment where that was realized even by him. So really, the emperor has no clothes here, and the president is trying to get away with murder, a murder of the separation of powers doctrine.
I want to push this just a little bit further, and like to dramatize the absurdity, Justice Gorsuch proposes another version of a version of a hypothetical.
Could the president impose a 50% tariff on gas-powered cars and auto parts to deal with the unusual and extraordinary threat from abroad of climate change?
It's very likely that can be done. That's very likely.
I think that has to be the logic of your view.
Yeah, in other words, now obviously this administration would say that's a hoax, it's not a real crisis, but...
I'm sure you would.
Yes, but that would be a question for Congress under our interpretation, not for the courts.
All right.
Okay, so do you think Gorsuch's hypothetical here with regards to the climate change, that he's sure they would declare a hoax, which is just funny to me that it comes up in this case. So is this an accurate representation of what would be the consequence, back to being serious, of upholding the delegation of power in a way that the president's team wants the outcome they desire from this case? Would this hypothetical Gorsuch presents actually be a possible outcome?
I mean, I think so. But there's several things to note about this exchange, where again, is another emperor has no clothes moment, because you see Sauer saying, first admitting the logical consequence. Yeah, by the argument he's just made, then Democrats could use this power too to declare a foreign threat and impose whatever kind of regulations they want to at home. But then he realizes kind of what he said, and that doesn't sound very popular. The president doesn't like climate change. So, of course, we'd regard it as a hoax. And so you see him like doing the bidding of the master there. Like, and he himself is saying a kind of tongue in cheek of, well, I suppose we'd say that it's hoax. So like you see, he doesn't really even believe what he's saying, that there's something funny here. But yeah, what I think the concession shows is that there's no intelligible principle here for what can and can't be delegated. And so if the president now can declare his so-called emergency from trade deficits and use that to impose sweeping tariffs on trade with the rest of the world, yeah, there's no reason why a Democratic administration couldn't do the same thing and regulate our use of cars. And that's something that means that this kind of style of reasoning, where as long as you can declare an emergency without any kind of reviewable reason, it's a complete recipe for autocratic rule. I think Gorsuch sees this, and he's rightly critical of it. And he adds further complications, such as what he calls the retrieval problem. So one argument that the administration can make is, well, there's still a check on the president's power because there are provisions in IEPA for Congress to be able to declare it's not an emergency and therefore end the power of the president. And they did something like this with regard to IEPA during COVID. There was an IEPA-imposed emergency that Congress overturned. But as Gorsuch himself points out, yeah, but the president still has the power to veto that decision of Congress. And what president who wants to have an emergency power wouldn't veto Congress's revocation of it if he still wanted to have the power? And that's your problem of autocracy right there. It's true that a veto can be overridden in the American Constitution, but then you need a supermajority. You need 2/3 majority in, I think, both houses in order to overturn that veto. And so this is why there's a retrieval power, because once this power is granted, it's practically impossible for the president to get it back, especially because it's not judicially reviewable. And so Republicans today may very well like the fact that Trump gets to exercise these autocratic powers on behalf of causes they care about, such as their concerns about the trade deficit, their concerns about the role of American manufacturing, the American blue-collar worker, etc. Uh, but are they going to like it when the Democrats use the exact same power that they've argued for to impose regulatory control over the oil industry, over automobiles, and you know, classic American values? It's absurd. And anybody who cares about not just this particular policy, but about the rule of law, about freedom in America, should realize what we're talking about here is a precedent that, if it is not overturned, I mean, will basically give any party in power any kind of autocratic license they want to run a kind of economic dictatorship in this country.
How do you think, in more detail, should the law be scrutinized? Because yes, we now have an issue. I'm still struggling with that idea. Okay, the IEPA has some legitimate powers that it delegates and enumerates to the president that seem to be valuable and important and crucial for the president to execute his functions. And on the other hand, you just striking down tariffs. We just kind of concluded, and you concluded that striking down tariffs as something Congress didn't delegate for this law would not be sufficient. So what else? What should be done?
I mean, it is something that the Supreme Court sometimes does, to strike down provisions of a law, not to strike down the whole thing, but to strike down the parts of it that it judges as being unconstitutional. And like, I think it should do that in this case with regard to, for example, that very ambiguous line about otherwise, and the very ambiguous line about regulate. I mean, the word regulate itself, we haven't talked about this yet, but it is ambiguous. It's like, at the time of the founding, when Congress was talking about its power to regulate interstate commerce, for instance, that was put into the Constitution in order to tear down trade barriers among the states, because they existed prior to the Constitution. In the Articles of Confederation, there were tariffs between the states. Those are illegal because Congress has the power to regulate interstate commerce, which at the time meant to make regular. That is, to make uniform across the states. You can't have these, one state has one tariff barrier and the other state has another one. So it's kind of ironic that this language of regulation, which originally in the Constitution was there to tear down tariff barriers, is now being used to impose them, because the word has come to mean something else. The word has come to mean kind of paternalistically impose rules on, usually preventative rules. And so this is, in fact, the kind of thing you should be able to do when you're dealing with trade with enemies during wartime. You should be able to regulate it in that sense. You should be able to paternalistically stop somebody from trading with an enemy. But the fact that it is so ambiguous, what we're talking about here, and for what kind of reasons, there's going to be deadly consequences if this word is taken in an unqualified way to grant some kind of power. The fact that Congress wasn't more specific about what it meant there is deadly. And so there's other problems with IEPA, like the fact that it is triggered not just by emergencies to national security having to do with military threats. But here, I'll read the passage that's in. These are the triggering conditions for when the president can use these powers. Any unusual and extraordinary threat which has its source in whole or substantial part outside the United States to the national security, foreign policy, or economy of the United States. And just the fact that it's got economy in there, what's a threat to the economy? I mean, that could be so many different things. The way they're reading it here is to mean, well, there's a threat to basically uncompetitive domestic manufacturers. I mean, how many other interest groups in this country get to say that when their business is threatened by whatever reason, that's a threat to the economy of the country, and therefore the president has grounds to declare an emergency and impose basically whatever kind of trade regulations that he wants to. And they're treating foreign productiveness as an economic threat. This is just notoriously non-objective and vague language that I think is grounds. It's also grounds, apart from the non-delegation concerns, it's also grounds, I think, for declaring these provisions of the law to be unconstitutional. There actually is an old doctrine in Supreme Court jurisprudence called voiding for vagueness. Now, usually this doctrine is used for other kinds of purposes. In the 20th century, it was used to declare unconstitutional various municipal codes that were thought to violate civil rights. So, for example, in Coates versus the city of Cincinnati in 1971, there was a city ordinance that outlawed assemblies that annoy the passerby. So the Congress struck that down, saying it's vague what it means for an assembly to annoy a passerby. That could mean any number of things. It's the kind of law that allows the government to use its discretion to decide who it's going to arrest for violating this law and who it's not. That means that people can never really know whether they're violating the law or not, and therefore it should be void for vagueness. And this is just my view, but I think there should be a comparable kind of void for vagueness principle that's applied outside of the civil rights context. I mean, if we care about protecting our citizens from arbitrary local municipal codes because they don't know whether the local police are going to arrest them or not, because of the vagueness of these laws, don't the rest of us across the country deserve protection from a president that's going to use the entire apparatus of the federal government to regulate our whole economic existence for basically any reason he likes? And we can never predict what kind of conditions are going to allow him to do that, because he can basically declare any kind of economic threat, quote unquote, to the nation an emergency. That is completely non-objective. It is a threat to American liberties. I think it's notoriously vague and deserves to be voted as void and unconstitutional for that kind of reason. And here, I think is a good chance to step back from this particular question, just to say something more generally about why having objective law is so crucial to the protection of individual liberties. Because the Constitution, the founders gave us a Constitution that enumerates government-specific powers, enumerates them, saying beyond these powers, nothing else is permitted of the government. And the trouble with non-objectively written laws is that they reverse this equation. And we should take a look now at this passage from Ayn Rand where she comments on this. Do you want to read this for us, Robertas?
Yes. So Ayn Rand says, instead of being a protector of men's rights, the government is becoming their most dangerous violator. Instead of guarding freedom, the government is establishing slavery. Instead of protecting men from the initiations of physical force, the government is initiating physical force and coercion in any manner and issue it pleases. Instead of serving as an instrument of objectivity in human relationships, the government is creating a deadly, subterranean reign of uncertainty and fear, by means of non-objective laws whose interpretation is left to the arbitrary decision of random bureaucrats. Instead of protecting men from injury by whim, the government is arrogating to itself the power of unlimited whim, so that we are fast approaching the stage of of ultimate inversion, the stage where the government is free to do anything it pleases, while the citizens may act only by permission, which is the stage of the darkest periods of human history, the stage of rule by brute force. And that's from Ayn Rand's The Nature of Government essay, written in 1963. So, in connection to what Rand is saying, I want to play one last clip where Justice Gorsuch talks about the constitutional assignment of government powers and how the issue of taxation was crucial to the American project to establish a kind of government like the one Ayn Rand championed and the one she warned us against.
It does seem to me, tell me if I'm wrong, that a really key part of the context here, if not the dispositive one for you, is the constitutional assignment of the taxing power to Congress. The power to reach into the pockets of the American people is just different, and it's been different since the founding and the Navigation Acts were part of the spark of the American Revolution, where Parliament asserted the power to tax, to regulate commerce. Some of those were revenue raising, some of them didn't raise a lot of revenue. We had a lot of pirates in America at the time. And Americans thought even Parliament couldn't do that, that had to be done locally through our elected representatives. Isn't that really the major questions, non-delegation, whatever you want to describe it, isn't that what's really animating your argument today?
I think it's a huge piece of what's animating our argument. Thank you.
In light of what Gorsuch says in this clip, Ben, my question is, do the administration's defenders, do you think, are betraying the fundamental constitutional assignment of powers and, by extension, the whole principle, the fundamental principle upon which the American Revolution was fought?
Yes. And some of it comes out in what Justice Gorsuch just said, but some of it also comes out in a lot of other things that we can see in the mode and style of the arguments that are being made by the president's lawyers. So, and there is simply the fact that, yes, tariffs are taxes, and they want to delegate the taxation power away from Congress to the president. And it's not just the fact that there's something un-American about the delegation of unlimited power to the president in a way that violates the separation of power. It's even the kinds of arguments that they use to try to rationalize their ability to do this. I've read a lot of the briefs now, and a lot of the amicus briefs, both for and against this case on both sides. And one of the things that stood out to me is just how un-American some of the arguments are. And un-American in a way that feigns scholarship, but is really desperately trying to evade the fact that there are basically un-American premises at work in these arguments. So, for example, in the president's lawyer's own briefs, there is an argument that for why it should be okay for Congress to be able to delegate foreign commerce power to the president. Now, we've talked about cases where it can be if it's, constrained by an intelligible principle, but what's the president's reason for thinking it's okay to do it? It's not because of, as long as it's subject to some kind of rule of law constraint. It's that if you look historically, the power to regulate foreign commerce used to be the power of the king. That is actually the argument they make. And because it used to be the power of the king, therefore should be less problematic to give it back to the president, who is the executive just like the king was. Now, the major aspect of American history that this argument is careful to evade and to paper over is the fact, and they're making it as a kind of originalist argument, the idea if you look, you can try to interpret the meaning and intent and function of these laws by looking at the legislative and the history going back to the founders and going back to English common law, etc. And it's true that there was a period of time where the power to regulate foreign commerce was the power of the king, right around after the Glorious Revolution, 1688. Now, it's worth noting that Parliament, even in England, eventually takes this power back from the king. They don't like the fact that the king has this power. And sometime after the American Revolution, they succeed in fully pulling it back from the king. But leave aside the question of whether they're even accurately representing the English legal history here. There's the mere fact that we know Congress stripped the power to regulate foreign commerce away from the executive in the Constitutional Convention. They did this because they didn't want him to be a king. And so the fact that it used to be the king's power is blissfully irrelevant, and to ignore it is to ignore what was so revolutionary about the American Constitution, that it did not want the president to be a king. The president's lawyers even cite this book by Michael McConnell, The President Who Would Not Be King, to get this point of history out there that it used to be the king's powers. But shouldn't the title of this book tell you something? The President Who Would Not Be King. And in fact, it's the thesis of the book that that the founders wanted to strip these things away from the king. And that was what was so revolutionary about it. And the author, Michael McConnell, actually wrote the brief for the petitioners, explaining what was unconstitutional about the president's argument. So this is just maddeningly dishonest and un-American. The other one is that in some of the same briefs, these ones are more coming from the amicus briefs of the allies of the president's lawyers, where they try to argue for why we should think of tariffs not as taxes but as regulations. And to do this, they point out, well, tariffs can sometimes be used for regulatory purposes. And they argue, again, trying to make a kind of originalist argument, that there were American revolutionary pamphleteers during the time of the Revolution who distinguished between taxation and regulation. And they say, well, we all know that the American revolutionaries were against taxes, but they were in favor of or conceded the right of Parliament to regulate commerce. Now, again, keep in mind they're talking about Parliament, not the king. But even leaving that aside, I looked at the pamphlets that these people were citing, that these scholars are citing, and they're just so misrepresenting what's in the pamphlets. If you look at pamphlets by people like Richard Bland or John Dickinson, who are some of the ones they explicitly cite, first of all, like Dickinson, for instance, is not unqualifiedly in favor of foreign commerce regulation. He was against the Navigation Acts, which Gorsuch mentioned. That was regulatory and not taxation. That was the way that the Parliament had basically imposed the power, stopped the colonies from trading with anybody other than Great Britain for certain kinds of commodities. And Dickinson was against that. But not only that, and this is the biggest one, this is the one that should be most obvious to anybody who's taken just a high school level course in American history. What were the taxes that the revolutionary pamphleteers were opposed to? They were opposed to import taxes on tea, lead, glass, the ones that led to the Boston Tea Party. Now, they were opposed to taxation without representation, not just taxation as such. But that means what they thought import taxes were legitimate only if they were authorized by their legislature, which is exactly what the president is now trying to take the power away from Congress to do. He wants to be the king who can impose taxes on imports, just like Parliament, at the behest of King George II, did in the Revolutionary War. So it's George III. Sorry, it's just absurd. It's absurd that they would paper over this kind of history, paper over like the most glorious moment of the American Revolution to try to justify this kind of sweeping power to the president on the year that's the 250th anniversary of the Declaration of Independence. I mean, it's just maddeningly absurd and atrocious, and the Supreme Court has got to do something about it.
Yeah, the phrase that became popular recently and popularized by some protests around the United States, "no kings," I think is taking very serious meaning in this conversation and in the case.
More serious than the people at the protests, I think, take it. Yeah.
Yeah. So finally, Ben, I want to wrap up, and I have one last big question for you. And so, given everything and we've discussed today, and looked at the oral arguments and how they are developing, what is the best possible outcome, do you think? And the best possible outcome for liberty, for American liberty, for liberty of every individual in the United States? And do you think achieving a wholesale overturning of IEPA or something close to that is a realistic expectation? Or what do you think the outcome is going to be?
So I think the best outcome would be to overturn the provisions of IEPA that are non-objective, that grant the president this kind of unchecked regulatory power. I don't know that that's going to happen. I think it's very likely that the tariffs will be struck down by a 5-4, maybe even a 6-3 decision, really kind of depending on the way Barrett goes. It seems pretty clear that Gorsuch is skeptical of these tariffs. I think what you might have is a kind of split decision where you have different parties voting against the tariffs for different reasons, where they have what they call concurrence in judgment. That is, they say they all agree these tariffs should be struck down, but for different reasons. And so I think you'll very likely get a Gorsuch saying they should be struck down on non-delegation grounds, because this is very much his concern from jurisprudence perspective. And I think he's tipping his hat to that various places in the oral arguments. So I think he'll say they should be struck down. The provisions of the law should be struck down for those kinds of reasons. I don't see the kind of liberal justices striking them down for those reasons. I see them trying to find a kind of legalistic loophole or interpretation of the language of IEPA whereby, yeah, that law is valid, but the president doesn't have the right to use it to impose these tariffs. So I think it's likely the tariffs will be struck down. I don't think we're going to get the overturn that I would like. But I do think that even if they're struck down, short of that overturn, it'll still be better than nothing. And it'll take the wind out of the sails of the president's particular authoritarian agenda. His having this kind of power to impose unlimited tariffs is kind of the linchpin, the keystone in his, uh, 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 ballooning authoritarian agenda to control various aspects of the economy. It's what he uses to pressure all kinds of different corporations to do his bidding. And so, if that's taken out of his hands, it's really going to disrupt his agenda. And even if the law isn't overturned, if Gorsuch at least gives his reasons for overturning why we should overturn it, I think that at least start a conversation and a kind of quasi precedent. Going to revisit laws like this and be much more scrutinous of the non-delegation question, and not only with them, but future laws that Congress passes. So I don't think we'll get the full overturn that I'd like to see of those provisions, but if there's at least the overturn of the tariff, I think it'll be good and it can start a good conversation.
All right. Well, thank you, Ben, for following this and researching and writing about this. It's definitely a crucial issue, and I feel enlightened following it. And I think it's important for everyone to know what's happening here in some sense. And to wrap up, I want to offer some resources that would help get even more context on these issues. So two of them are by Ayn Rand, and one is you can see all those resources in the description of the podcast. Follow the links. We will post them whatever you're watching or listening to this. So first is the entry in the Ayn Rand lexicon, where she talks about law, objective and non-objective, and makes a distinction and explains what makes it so. Then Ayn Rand's essay we mentioned above and quoted is The Nature of Government. And apart from Ayn Rand, it's, like I said, Ben, you've written extensively on this issue. So your essay, The Constitutionally Dubious Law Empowering Trump's Emergency Tariff Authority, and the other essay, The President Has No Foreign Policy Discretion to Impose Sweeping Global Tariffs. Follow the links for those essays by Ben. And as far as I know, you have another forthcoming piece on un-American arguments that the president's lawyers are making, that you explained a little bit for our discussion, but I think you're going in more detail in that essay that's coming soon.
Yeah, I'm not sure if it'll be out by the time this podcast is released. If it is, we'll put a link for it in the notes too.
All right. Thank you for watching and listening. Please subscribe, comment, share on YouTube or Facebook or whatever you're listening to this, whatever your media channel is, and send us some questions or comments to newideal@aynrand.org. Thank you, Ben.